you do in the first hours after a fall can decide whether your claim is taken seriously or dismissed. Let me walk you through the exact steps to protect your health, your evidence, and your right to compensation in a slip and fall case. Hi, I'm attorney Greg Oberg. For over 30 years, my firm and I have been fighting for injured Texans, working to get every client the maximum compensation they deserve. If you or your loved one have been hurt in an accident, let's talk. Give us a call at 972-682-9700 for a free consultation. Let's go through the steps one by one. Step 1. Seek medical attention immediately. Your health comes first, and it also anchors the entire claim. Get evaluated the same day if possible. Falls can cause head injuries, internal injuries, or ligament damage that does not show up right away. Early care creates a timestamp that links your symptoms to the incident and helps prevent the retailer from arguing that something else caused your condition. Be specific with providers about what happened, where you landed, and what hurts. If you cannot work, ask for written restrictions. Those chart notes become evidence later, not just memories. Step 2. Report the incident to the store. Once you are safe and stable, make sure the incident is formally on the retailer's radar. Ask to speak with a manager before you leave. Request that an incident report be created and ask for a copy or at least the report number and the name of the person who took it. Keep your description factual and short. State where you fell, what you saw, and what you felt. Do not guess about causes, do not accept blame to be polite, and do not downplay pain. If the hazard is still present, point it out so the condition gets documented. Reporting promptly prevents the "it never happened here" defense and sets up your evidence work. Step 3. Document everything. Now that the event is on record, capture what the scene looked like before it changes. Start with photographs from several angles. Get wide shots that show the layout and lighting and close shots that show the hazard. Take photos of footwear, clothing, and any visible injuries. If you slipped on a spill, photograph footprints or track marks, dirty paper towels, or other signs that the substance had been there for a while. If you tripped on a broken tile or curled mat, include measurements with a coin or card for scale. Ask for names and contact information of witnesses. Save receipts from the store and any purchases connected to the visit. Keep every medical bill, prescription receipt, and mileage log for appointments. Documentation is your lifeline because major retailers often clean and fix hazards quickly once someone is hurt. Your photos and notes may be the only proof that the danger existed. With the basics preserved, protect yourself from the most common misstep that can undercut all of this work. Step 4. Do not talk to the retailer's insurance company without legal advice. After a report is filed, an adjuster may call. Their job is to protect the company's money. They may ask for a recorded statement or try to get you to agree to a quick settlement before your injuries are understood. Keep calls brief and polite. Confirm claim details, then ask that requests be sent in writing. Decline recorded statements and do not sign broad medical authorizations that open your entire health history. It is fine to say you are under evaluation and will provide appropriate documentation at the right time. This creates breathing room for you to learn the rules you actually have to prove. Step 5. Understand the legal standard for slip and fall claims. Once you've handled the immediate aftermath and preserved key evidence, it's important to understand how Texas law views slip and fall cases. In Texas, you must prove the store was negligent. That means a hazardous condition existed, the store knew about it or should have known about it with reasonable inspections, it failed to fix or warn, and that failure caused your injury. Two ideas drive most outcomes. First, notice. Actual notice is when the store knew about the hazard. Constructive notice is when the hazard existed long enough that a reasonable store would have discovered it. Your photos, witness accounts, and the store's own inspection logs often answer that question. Second, causation. You need to connect the hazard to the fall and the fall to your injuries. Your medical records and consistent timeline do that work. Expect arguments that the hazard was open and obvious or that you were distracted. Targeted evidence about lighting, placement, and the visibility of the hazard helps you answer those claims. Step 6. Keep a record of your damages. Once you understand the legal target, keep a careful record of how the fall is affecting your life. That is what turns a report into a value. Recoverable damages in Texas include medical expenses, lost income, and the human toll of pain and loss of enjoyment. Create a simple folder for bills and explanations of benefits. Ask your employer for a letter confirming time missed and any modified duties. Track out-of-pocket costs like parking, transportation to therapy, or medical equipment. Keep a daily journal of limitations. Record how long you can stand, how far you can walk, what household tasks you had to hand off, and what activities with your family you have paused. Scars and swelling should be photographed at intervals. Precision beats generalities. When your notes match your doctor's records, your claim becomes both clear and credible. Step 7. Understand the claims process. With your damages documented, the next step is understanding how the claim will be built and presented. Here is how a typical retailer claim unfolds. First comes investigation. Your legal team gathers medical records, the incident report, photographs, witness statements, and requests preservation of surveillance footage and maintenance logs before they are overwritten. Next comes a demand once your treatment plan stabilizes or your doctor can project future care. The demand explains the facts, the legal duty, the breach, and the damages with a clean chronology. Negotiation follows. Insurers often start low and test for weaknesses. If meaningful progress does not occur, a lawsuit is filed within the statute of limitations, which is generally 2 years from the date of the fall. Litigation opens discovery, which allows subpoenas for video, cleaning logs, inspection policies, and depositions of employees. Many cases settle during or after discovery because the facts come into focus under oath. Knowing this arc reduces anxiety and helps you make good timing decisions, like waiting until you reach maximum medical improvement before discussing a final number. Step 8. Be prepared for the retailer to push back. You now have the process map. The final step is to prepare for the pushback large retailers routinely deploy and to meet it with structure instead of stress. Expect arguments that the danger was obvious, that the store did not have enough time to discover the condition, or that you were distracted. Expect requests for recorded statements and broad medical releases. Expect surveillance to be unavailable unless it was preserved early. None of this is personal. It is a playbook. Your response is a playbook too. You already reported promptly, documented the scene, and kept medical care consistent. You have a clear summary of damages, not a stack of loose bills. You have a timeline that ties the hazard to the fall and the fall to the injuries. If negotiations stall, you are ready to file and use discovery to obtain logs, training materials, inspection routes, and footage. Preparation turns pushback into progress because the other side has to engage with documents and sworn testimony rather than spin. After a fall, evidence fades fast, and insurance companies move even faster to deny or minimize your claim. The most important step you can take is getting a lawyer who knows how to protect your case from day one. At Oberg Law Office, we've been helping injured Texans for over 30 years, and we know how to make sure your story is heard and your rights are protected. If you or someone you care about was hurt in a slip and fall, call 972682970. Let's talk about what happened and how we can help you move forward. And if this video helped you, don't forget to subscribe and check out the next one.